This is part 22, and in this part we will start discussing section 405 of the Indian Penal Code, which defines the offence of criminal breach of trust. As usual, in order to understand this, let us start with very simple illustration. I meet my friend and I hand over my book to my friend with a request that it should be given to my relative. The friend agreed upon, and when he went home, when he started reading the book, he decided to make that book as an addition to his library, and he never handed out that book to my relative. What is his liability? Now, he is not liable for any one of the sections with which you are dealt so far. As far as the offences against property is concerned, it cannot be said that he is liable for the offence of theft. The question of extortion doesn't arise, as it doesn't fall under either theft or extortion. The question of robbery, question of dacoity, and then the question of dishonest misappropriation of the property doesn't arise. I had entrusted that property to him. I had given that book to him so that it should be given to my friend, and then what I had done, he was entrusted with the property. So if you read section 405, it says, whoever being in any manner entrusted with the property or within any dominion or property dishonestly misappropriates or converts to his own use that property, or dishonestly uses or disposes of that property in violation of any direction of law prescribing the mode in which such trust is to be discharged, or of any legal contract, express or implied, which he has made touching the discharge of his trust, or willfully suffers any other person so to do, commits criminal breach of trust. So, liability to whom the book was given is for the offence of criminal breach of trust as far as section 405 is concerned. Right from section 406 up to section 409 are the sections which deal with punishment. And then, if you just read the heading, 406 deals with general punishment for criminal breach of trust. Section 407 deals with criminal breach of trust by carrier. Section 408, criminal breach of trust by clerk or servant. Section 409, criminal breach of trust by public servant or by banker, merchant or agent, as it is there. So what is their liability and what is the quantum of the punishment that can be inflicted by the court of law is dealt as far as these sections are concerned. Now, if you start, this offence of criminal breach of trust can be committed with respect to movable as well as immovable property. Imagine a situation where Mr. A is appointed as an executor of the will, and he is supposed to dispose of movable as well as immovable property, but he has not followed the directions which are given in the will and given more share to somebody, or has converted that property to his own use. What is his liability? He was entrusted with the property, and hence his liability is for the offence of criminal breach of trust as defined by section 405. Your neighbor wanted to go for a journey for a few days, and instead of, there was no time for him to go to the and keep that ornaments in the safe locker. He handed over to you, and then you converted it to your own use. Your liability is for the offence of criminal breach of trust. You want to carry goods from one place to another place, hence you go to the carrier, hand it over to the carrier, and what the carrier has done, carrier has sold out the goods before they are taken to the destination, or before they are handed over to the person who was directed by you to be handed over. Your liability, his liability is for the offence of criminal breach of trust. So now, what is criminal breach of trust? In order to constitute liability for the offence of criminal breach of trust, the police starts with the wording, whoever being in any manner entrusted with the property. So you have the property in fiduciary capacity, because of which you don't claim ownership. You don't become owner of the property, but then you have got, you have got property with you for a particular purpose. For example, you want to go on journey, and in order to take care of your furniture, you go to the warehouse keeper and tell him, take care of my furniture till I come back. Now what is he doesn't become owner. His role is merely he will charge you for that as far as the charges for warehouse keeping is concerned, and then when you come back he has to return. If he doesn't return, and if he has already sold out that property to somebody or converted property to his own use, his liability is for the offence of criminal breach of trust as far as section 405 is concerned. So there we have learned this offence can be committed with respect to movable as well as immovable property. Now it's not only the property must be entrusted. If he has got dominion over the property, and what do you mean by dominion over the property? It is not entrusted to him, but he has got control over the property. If Mr. A is working as an inspector as far as water works department of the corporation is concerned, he has got entire control as far as the distribution of the water is concerned. Or if somebody is working with the electricity board, he has got control as far as the giving of the connection is concerned. Now such a person may be from the water works department or maybe from electricity department. When he has been bribed by somebody and he takes illegal connection, though he has got proper water is not entrusted to him or electricity is not entrusted to him, what is the result? He becomes liable. He becomes liable for the offence of criminal breach of trust because he has got control over the property, he has got dominion over the property. And what is the duty that is cast? When you have got dominion over the property, when you have got control over the property, you must use that property as per the directions which are given. For example, there can be contract also. Mr. A from one place decided and agreed upon to send money of 10 lakhs rupees per month to Mr. B, and then with a request that it should be invested for the purpose of purchasing shares of a particular company, because B was expert as far as share market was concerned. Now this is required to be done. This man, when B receives 10 lakhs rupees, he has not purchased the shares but has used that amount for some other purpose. What is his liability? He has committed the offence of criminal breach of trust. And the wording of the section, whoever being in any manner entrusted with the property or with any dominion dishonestly. So this man, instead of purchasing shares of a particular company agreed upon, purchases some other company which is in the interest of the person for whose he has purchased. He has not done this act dishonestly, and hence the question of liability doesn't arise as far as section 405 of the Indian Penal Code is concerned, which defines the offence of criminal breach of trust. Now this can be, as this further part of the as you go on reading the illustrations. But before you read the illustrations, the time for me to draw what is an entrustment. When you are serving somewhere, the amount that you have to pay income tax, and that income tax is required to be deducted by the employer at the source. So before paying you the salary, he will deduct the amount as far as your contribution or your income tax is concerned, and then that will be sent to the income tax department accordingly. Now it is deducted at the source, but though it is deducted, though it is not handed over, so entrustment does not mean you should hand over. One who has deducted the amount automatically, that is entrusted to him, so that it should go as far as your income tax account is concerned. If it is not done by him, if the amount is deducted but that is not paid as far as your income tax is concerned, he commits the offence of criminal breach of trust as far as section 405 is concerned. And the two explanations to the section which are very lengthy, and hence I don't want to read those explanations. But if employer has deducted your provident fund, then whatever amount which he has deducted at the source is entrusted to him, so that it should go to your provident fund account. And if it is not so, he has not done so, he has spent that amount, then he commits the offence of criminal breach of trust as far as because of the first explanation to section 405. And the second explanation deals with a person being an employer who deducts the employee's contribution from the wages payable to the employee for credit to the employee's state insurance fund held and administered by employee state insurance corporation established under. So this is contribution towards ESI is deducted, that must go to the account, and if that doesn't go to the account, his liability is for the offense of criminal breach of trust as per section 405 of the Indian Penal Code is concerned. And then if you read, go on, go through the illustrations which are given. A carrier is entrusted by Z with property to be carried by land or water. He dishonestly misappropriated the property. He has committed the offense of criminal breach of trust. If you are a revenue officer, he is entrusted with public money and is either directed by law or bound by contract express or implied with the government to pay into certain treasury all the public money which he holds. He has collected the money and he has to deposit into the treasury. If he doesn't, then his liability is for the offense of criminal breach of trust. A is a warehouse keeper. Z is going on a journey and trust his furniture to A under a contract that it shall be returned on payment of stipulated sum for warehouse room. A dishonestly sells the goods, he is liable. And hence now, as you go on reading section 405 of the Indian Penal Code, you come to know, to constitute an offense of criminal breach of trust, it is essential that the prosecution must prove first of all that the accused was entrusted with some property or with any dominion or power over it. It has to be established further that in respect of the property so entrusted, there was dishonest misappropriation or dishonest conversion or dishonest use or disposal in violation of direction of legal contract by the accused himself or by someone else which he willingly suffered so to do. It follows almost automatically that this definition, that the ownership or beneficial interest in property in respect of which criminal breach of trust is alleged to have been committed, must be in some person other than the accused, and the latter must hold it on account of some person or in some way for his benefit. So this is as far as as I told you, as you go on reading, reading the illustrations which are given, which serve the purpose to understand section 405 of the Indian Penal Code, which defines the offense of criminal breach of trust, which can be committed with respect to. So the person is deprived of his property. How he is deprived of his property? He had entrusted that property to somebody, or somebody had dominion over the property, and such a person dishonestly misappropriates or converts to his own use, constitutes liability as far as section 405 of the Indian Penal Code is concerned. With this, as I told you, up to section 409 of the Indian Penal Code are the sections which deal with punishment. And hence now this is the time for us to understand one more term, and then we want to understand what do you mean by stolen property. Stolen property is defined by section when it can be said that my book is a stolen property. It can be said that my book is a stolen property if somebody has committed theft with respect to the property and A has got property by committing theft, or Mr. B has committed the offense of extortion and he has got my book with him, or somebody has got property, Mr. C has got property by committing the offense of robbery, or Mr. D has got property by committing the offense of criminal misappropriation, or Mr. E has got property of my book by committing the offense of criminal breach of trust. So if you start now dealing with section 410, which defines what do you mean by stolen property, it says property, the possession whereof has been transferred by theft. So the possession, how the possession has been transferred? The possession was with me, but how it has been transferred to somebody else? A, by theft, or by extortion, B, or by robbery, C, or and the property which has been criminally misappropriated, D, and in respect of which criminal breach of trust has been committed, E, has got my book by committing offense of criminal breach of trust, is designated as stolen property. So when it is a stolen property, when possession of the property has been transferred by theft, extortion, robbery, or which has been criminally misappropriated, or in respect of which criminal breach of trust has been committed, is what is known as a stolen property. Now, that has been qualified whether the transfer has been made or the misappropriation or breach of trust has been committed within or without India. So it's not necessary that the offenses that are enumerated. So in order to understand stolen property, first of all, it is necessary for you to remember and understand 5 offenses. 1. Theft. 2. Extortion. 3. Robbery. 4. Dishonest misappropriation. And 5. Criminal breach of trust. If somebody has got property by committing any one of the offenses, whether the offense has taken place within the territory or outside the territory of India, it is immaterial. Then we say that property can be designated, or that property can be labeled as what is known as stolen property. But further part says, if such property subsequently comes into possession of a person legally entitled to the possession thereof, it then ceases to be a stolen property. So it's not a concept that once a stolen, always a stolen. No, certainly not. If that property subsequently comes into possession of a person legally entitled to the possession. So the properties with A, B, C, D and E by committing the offense of theft, extortion, robbery, criminal misappropriation and criminal breach of trust. Yes. And now I get back the property. I am legally entitled to the possession thereof, and I get the property. So when I get the property now, in such a case, the property is not at all known as a stolen property. It ceases to be what is known as stolen property as dealt by section 410 of the Indian Penal Code. So this is, as we are learning, offences against the property. This you have to understand one term and what is known as a stolen property. General impression, or which is carried by many, is when you say that it is a stolen property, the property which is stolen is stolen property. But no, what is stolen property? The property, the possession whereof has been transferred by theft, extortion, robbery, or which has been criminally misappropriated, or with respect to which the offence of criminal breach of trust has been committed, is what is known as a stolen property. With this, what to do with respect to such property when the matter goes to the court of law? And for that, this is nowhere mentioned as far as Indian Penal Code is concerned. But when you refer right from section 451 up to section 459 of the Criminal Procedure Code, and what is the heading of the chapter? Disposal of the property. What to do with respect to property? And as few of the sections deal with what to do with respect to the stolen property is also dealt as far as the chapter is concerned. So as and when time permits, if you refer to right from section 451 up to section 459 of the Criminal Procedure Code of 1973, you will definitely understand what to do with respect to the property. But other than this is what is defined or what is meant. Now why that has been defined? That has been defined because right from section 411 up to section 414 are the sections which deal with punishment. And what is section 411? It says, whoever dishonestly receives or retains any property, knowing or having reason to believe the same to be stolen property, shall be punished with imprisonment of either description for term which may extend to 3 years, or with fine, or with both. 411 says dishonestly receiving stolen property. And here, to understand one term, whoever dishonestly receives or retains any property knowing or having reason to believe. And in order to understand what is reason to believe, you being the student of law, you have to know the meaning. And in order to know meaning of what do you mean by reason to believe, you have to refer to general explanations right from section 6 up to section 52A and read. Reason to believe is defined by section 26, which says a person is said to have a reason to believe a thing if he has got sufficient cause to believe that thing, but not otherwise, as defined by section 26 of the Indian Penal Code. Now section 412, dishonestly receiving property stolen in commission of a dacoity. And it says whoever dishonestly receives or retains any property, the possession whereof he knows to have or has reason to believe to have been transferred by commission of dacoity, or dishonestly receives from a person whom he knows or has reason to believe to belong or have belonged to a gang of dacoits, property which he knows or has reason to believe to have been stolen, shall be punished with imprisonment for life or with rigorous imprisonment for term which may extend to 10 years and shall also be liable to fine. Section 413 deals with the cases where habitually dealing in stolen property, and it says whoever habitually receives or retains or deals in any property which he knows or has reason to believe to be stolen property shall be punished with imprisonment for life or with imprisonment of either description for term which may extend to 10 years and shall also be liable to fine. With this now, last section, section 414 deals with assisting in concealment of stolen property, and it says whoever voluntarily assists in concealing or disposing of or making away with property which he knows or has reason to believe to be stolen property shall be punished with imprisonment of either description for term which may extend to 3 years or with fine or with both. So these are the sections which, once you understand what do you mean by stolen property, you will understand why you should know what is stolen property and why it has been defined, because receiving or retaining stolen property, that is a duty which has been cast, legal duty that has been cast. Otherwise your liability may be as per any one of the sections, right from section 411 up to section 414 of the Indian Penal Code. With this, in the next part, we proceed to deal with last section where a person is deprived of his property, and that is defined as per section 415 of the Indian Penal Code is concerned, which defines the offence of cheating. 415 defines the offence of cheating. 416 defines the offence of cheating by personation, and then the aggravated form. There are, rest of the sections deal with punishment, but section 420 deals with what? Cheating and dishonestly inducing delay. Cheating when it results into delivery of property, that is made punishable as far as section 420 is concerned. So during the next part, we shall start discussing section 415, that is the last way in which a person is deprived of his property by committing the offence of cheating. By somebody cheats you, and he has deprived you of your property, and rest of the provisions with which we will continue our discussion as far as next part of our lectures is concerned.